Thanks, John, for the nice introduction, and welcome everyone. We're going to try and move right along and keep right on time here today so that you can get in the full 2 hours worth of credit. But before I recognize the faculty, I'd also like to recognize our colleague from the Mercatus Center, Satya Thallam. Satya is the head of the Mercatus Center's Financial Markets Working Group and has been invaluable in helping us put together this continuing legal education course. And we thank you very much for that, Satya. Our faculty today is Joshua D. Wright, Professor of Law from our own George Mason University. Professor Wright holds a JD and a PhD in economics from UCLA, where he was managing editor of the UCLA Law Review. And he holds a BA in economics with the highest departmental, excuse me, with the highest departmental honors from the University of San Diego, or the University of California in San Diego, a place that I'm sure Josh wishes he was today. In fact, with the heat, most of us probably would prefer to be there today. Professor Wright served as the inaugural scholar in residence at the Federal Trade Commission Bureau of Competition. And before coming to George Mason University School of Law, Professor Wright clerked for the Honorable James V. Selna of the Central District of California and taught at Pepperdine University's Graduate School of Public Policy. Professor Wright regularly lectures on economics, empirical methods, and antitrust economics to state and federal judges through George Mason University's Law and Economics Center Judicial Education Program. He has written scholarly articles for so many journals I would not begin to try and list them all for you today. And we will turn the program over at this point to Joshua Wright.
All right, so earlier this week I did all of antitrust law in an hour for a group of federal judges, so all of mergers in a half hour is a cakewalk. There's a lot. I may talk fast, but I want to get through at the end, talking through some sort of exemplar modern cases that I think will give you the best flavor for what modern merger analysis is about. But I want to start with, so we can sort of understand where merger law is now, where it's come from, because it's an important part of the story. So Clayton Act Section 7 is the operating statute. We'll get to what it says in a second. But a regulation of mergers in the antitrust sphere started back in 1914 with the Clayton Act. At that time, the Sherman Act had language that covered combinations generally, joint ventures, contracts, anything you can think of, but no specific merger prohibition. That came later. And so sort of the big watershed moments were the Clayton Act in 1914, the Seller-Kefauver Amendments in 50, and most importantly for our purposes, the Hart-Scott-Rodino Amendments in 1976. What they did, and this is sort of a big change that will motivate some of the things that we'll talk about, is created a pre-merger notification system, right? So if two parties are intending to merge through the Hart-Scott-Rodino process, they tell the agencies and supply a bunch of documents for the agencies to review. The agencies have some time, let's say something like 30 to 60 days, to review those documents and determine if they have questions. Okay? But it's a pre-merger notification system rather than an ex post law enforcement system. The parties merge, either the merger raised prices or it doesn't, or good things happen, something happens out in the world, and there's a law enforcement challenge to the merger after, as you might say, the eggs have been scrambled. The assets between the two companies have been merged. So sort of a pre-merger notification, a regulatory style system. Now this doesn't mean, and I won't get a chance to talk much about this, so if you've got questions about it, please ask them later. Doesn't mean that the agencies can't challenge consummated mergers. They can wait and then challenge the merger under the traditional Clayton Act. It's rare, and it's rare because the agencies don't like to, I'll stick with my breakfast analogy, unscramble the eggs once they've the merger has taken place, but it happens. So here's the statute. So this is the Clayton Act. The important parts I have put for you in red. This is the, the general authority that governs the FTC, or there's a private right of action, or the DOJ, in a challenge to a merger under the Clayton Act. So it says, in pertinent part, that a merger in any line of commerce or in any activity affecting commerce in any section of the country, the effect of such acquisition may be substantially to lessen competition or to tend to create monopoly. There's a lot of stuff in there. One is the any line of commerce. Sherman Act is a sort of Commerce Clause authority. What is commerce is more interesting in other areas of law right now, so there's really nothing interesting that happens in antitrust for this. Sort of most of the cases involve trade that's on a global level. Any section of the country may be substantially to lessen competition. There are two things that happen in merger analysis that really are the ball game. All right. One, notice that it's a prophylactic statute. We are predicting whether the merger the effect of the merger will be maybe to substantially lessen competition or tend to create monopoly. Double that up with the Hart-Scott-Rodino process. We're getting all of the information ex ante. We're going to review it. We're going to apply some economic analysis to make a prediction about whether the merger will substantially lessen competition. That's our standard. We're doing it all up front. We've got some tools to do it. I'll spend most of my time talking about the tools, right? But this is sort of from an analytical framework where we are. The any line of commerce, courts have subsequently interpreted to be, you may have heard of market definition in antitrust cases, which we'll talk a lot about. This is the statutory hook for that. Okay. So merger policy in the 60s and 70s is when things really got started under the antitrust law. A bunch of famous decisions in the 50s and 60s and 70s. Infamous in some circles. So you had Vaughn's Grocery is my favorite of them because I wrote a paper about the decision when I was in law school. The merger in that Los Angeles supermarket would have combined to about 5% share or something like that. The court stopped it. They said, well, this merger is not so bad. And indeed, we're pretty darn sure it's going to lower prices. But we see this trend out in there in the world of increasing consolidation. So consumers and lower prices aside, let's stop the merger. Justice Potter Stewart's dissent in Vaughn's sort of goes through, for the time period, very advanced economic analysis of the retail grocery market in LA and says, all of these decisions thrown together through the 50s and 60s, the sole consistency I can find is that in litigation under 7, the government always wins. Punchline, sort of fast forward 45 years later, that is no longer true. But we'll talk about why. The beginning of modern merger analysis is really this Philadelphia National Bank decision in 1963. Now, astute observers will note that 1963 decision that I'm calling the beginning of modern merger analysis predates the decision I just made fun of, right? So the 1966 Vaughn's Grocery decision had a different analytical approach than the 1963 decision. It is odd that they came in that order, but for our purposes, the important thing to know is that the way that the Clayton Act was interpreted from 1963 now sort of ignored everything that went on in Vaughn's Grocery and Pabst Brewing before that and Brown Shoe before that, sort of a line of sort of infamous merger decisions, striking down mergers between combinations with very small shares, and even in the face of evidence that there was certainly going to be lower prices because of the merger, and clung to this language in Philadelphia National Bank. And this language has become to be known as structural presumption in antitrust parlance. And the idea was, if we can find a merger in a market where we get the post-merger firm would control an undue percentage share of the relevant market and results in a significant increase in concentration, we're going to throw a presumption into the law. Plaintiff will, with evidence of the undue share in a relevant market, will have satisfied its prima facie case that the merger is illegal, that is, will substantially lessen competition under Clayton Act 7, okay? And the burden will shift to the defendant, okay? Now, what can the defendant do? The answer then was nothing, right? So the rebuttal case for a defendant, once the burden had been shifted, in modern antitrust, the defendant gets a chance to put on evidence that, listen, FTC challenging the merger, you say that there's undue concentration and you think prices will go up. Let us put on some evidence that says that there will be entry of new firms that will compete the price down. You can do that now, couldn't do that then. Efficiencies. You've not taken into account, plaintiff, that the merger will also reduce costs for everybody and that will push prices down even though there's increased concentration. Can do that now, couldn't do that then. So I'm calling this a burden shifting move because this is how it is in modern antitrust analysis. In 1963, it was the end of the ballgame. Right? If you could show undue percentage, plaintiff won. Okay? Now, this opinion I call the sort of the start of modern merger thinking, not because this is exactly what we do now, it's not, and that's where we'll go next, but because integrated into the law and how we structured burdens and presumptions was modern, at the time, industrial organization economic thinking. At the time, structural conduct performance thinking in economics sort of at its high point. This was the idea that by looking at the market structure, which firms had which shares, we could do a lot of really good predicting about what prices would be tomorrow. Okay? It was cutting edge at the time. It is no longer, but sort of got embedded into the law at the time. And, by the way, Philadelphia National Bank, still good law. Right? So one of the sort of deep confusions in application of antitrust law to horizontal mergers is we've got this odd structure. It's at least certainly not an intuitive structure where you've got Supreme Court law that has never been challenged, overturned, questioned in any way, shape, or form, and you have agency guidelines, the horizontal merger guidelines, which describe agency practice when the agencies will challenge a merger or not. Lower courts have largely adopted those agency guidelines. They've said the agencies have put forth a methodology. They're full of economists and antitrust experts. We believe that methodology. So lower courts, appellate courts have adopted the guidelines almost in toto. But these cases are still there. And so you'll get sort of an awkward tension where a plaintiff will say, under the merger guidelines, we win. Also, can we have that structural presumption? Because that's pretty helpful. And so you've got sort of a dual track analysis going on at the same time, and we'll talk through some of that. I told you you couldn't make efficiencies claims, that is a claim that a merger would reduce cost and therefore reduce price. Just wasn't in the law at the time. So I want to move to modern stuff. Okay, so I mentioned already this 1976 creation of the Hart-Scott-Rodino system. Procedural, fairly technical, really important, right? Really important because it was really what instigated what you might call an era of agency dominance in merger control. So the agencies, the DOJ and the FTC, had to be notified of the merger in advance. They would conduct their review, and 9 times out of 10, if they conducted the review and closed without challenging the merger went through and everything was fine, right? So you did not have the risk that you would scramble the assets of the two firms, lay off the people you were going to lay off, hire the new people you were going to hire, put up the new buildings, and then the merger would get challenged. Okay? That happens rarely now. It still happens, no procedural mechanism to stop it. But this really changed the ballgame for how mergers were analyzed. Put sort of right in the middle what the agencies were going to do and how the agencies were going to review the mergers. So shortly thereafter, the agencies felt some pressure. Merger analysis had been entirely a federal court thing prior to 1976. And the agency said, with all eyes on them, we should probably tell people how we think about mergers. What framework are we using to evaluate whether we are going to challenge your merger? One, to tell prospective merging parties what to expect. And two, you had, I've described it very quickly, but you had a lot of conflicting bits of economic thought and antitrust analysis and prior opinions, and the agencies wanted to clean some of that up. It at least have some influence over trying to get that stuff cleaned up. So they issued for the first time in 1982 a sort of brand new set of merger guidelines that tried to integrate all of modern economics at the time. They've been revised, 1982, then again 1992, again in 1997, and just last year. Okay? And so we'll talk about, I'm going to try to give you the highlights of what that evolution looked like, get through the 2010 guidelines, and talk a little bit about an important modern case that sort of shows off the guidelines approach. But this is, guidelines are really important in antitrust analysis. Now, here are some defining features of the guidelines from 82 to 97. The central idea, now we'll get to do some of the economics here. The central idea in antitrust analysis of mergers is the question, remember, go back to our Clayton 7, whether the merger will substantially lessen competition or tend to create monopoly. In antitrust economic parlance, the question continues to be, will the merger create some market power that did not exist but for the merger? Okay? So does the merger give incremental market power to the firms? Right? Now, from 82 to 97, a lot of what was going in the guidelines was still very structural in the sense that you probably, if you've followed antitrust at all, heard about market definition being a big deal in these cases. So the FTC challenges the Whole Foods merger, and the question is, the market premium natural and organic supermarkets, or is it places where you buy food? And XM Sirius, is it satellite radio? Is it places where you can listen to music or talk, or or is you singing in the shower part of the relevant market, right? So this is a question that determines a lot, and the reason it does is because a lot of what we figured out in terms of the economics, a lot of the methodology at the time was, let's define a market, figure out who has what shares in that market, and if the shares are high, we think that creates market power, there will be bad effects, and we will challenge the merger. It turns out most economic thinking between 1960s and the 2000 or so rejects that view. Concentration matters. It matters a lot less than we thought. Okay? In the guidelines, sort of from 97 to now 2010, the drafters of the guidelines were some of the leading economists, Carl Shapiro, who was at the DOJ, Joe Farrell, who was at the FTC. Carl, I think, is now in the Council of Economic Advisors. Were among the leading economists sort of leading this charge that said, we have the way we're thinking about predicting competitive effects a little bit off, so let's tweak it. And the idea was, from 97 to 2010, market power is still what matters. Ultimately, the idea is, will the post-merger firm be able to raise price and reduce output? That produces consumer harm. That's bad. That's what we're concerned about. That's the reason the antitrust laws exist. How we were thinking about the mechanism through which that firm could raise price was often a little bit outdated. Right? The idea that we could look out into the market, count the number of firms, and then say something reliable or even reasonably precise about what would happen in the market in the future was a methodology that's largely now been sort of set aside for what's in the new guidelines. So I want to talk about what's in the new guidelines. The punchline is going to be that the guidelines say anywhere and everywhere that we can possibly, rather than rely on indirect presumptions of market shares, directly test the competitive effects of the merger, let's do that, right? Concentration still matters. If we can't do better than concentration, we're going to use it, okay? And there still is, by the way, if a merger changes the post-merger share from, two firms have 50 and they goes to 100, people still pretty much believe concentration can help you predict that that's going to result in higher prices for 2-to-1 mergers. 3-to-2, 4-to-3, things get a little messier. So sort of creating a boundary on that, we don't believe in concentration that much anymore. Not in 2-to-1 mergers, we do. Okay? And so the idea was anywhere and everywhere we can get directly at effects, let's do it. To give you an example of that, I don't need that. To give you an example of a direct test. So in Whole Foods, FTC challenged the merger in Whole Foods. And in that merger, there was a big question about market definition, and the way that the court approached it was, and the way that the FTC put on evidence, I should disclaim, I was at the FTC at the time and part of this investigation. So the way that the FTC approached it is there were some markets in which Whole Foods had entered or exited the market, or some other premium natural organic, like Wild Oats was the firm they were going to buy, had entered or exited, and you could use those as experiments to test what happened to prices. Okay? So where you can produce direct evidence on pricing, you oughta, rather than sort of indirect presumptions. So the unifying theme is still, will the post-merger firm be able to do something to harm competition? Raise price, reduce innovation, reduce output, reduce quality, and I don't need that either. Okay? Or will the net effect be lower prices, more innovation, higher quality, etc.? The big move from the 60s to now has been not only from indirect presumption, sort of using rough and ready proxies to make predictions, to sort of more direct evidence. By the way, very helpful, we have, think about retail mergers, we have scanner data, we've got a ton of data and much better statistical econometric tools to do this stuff than we did in the 60s. And so we use them. So one change is from indirect to direct. The other is we now sort of more fully in the guidelines look at both sides directly. So we look at the anti-competitive theories where we get higher prices. We also look at will entry counteract those prices? Are the efficiencies from the merger? So we sort of do both sides of the scale. We rely less on presumptions, and we do it as directly as we can with economic data. On the anti-competitive side, there are really two different stories that one can tell. Two different economic theories about why a merger might result in increased market power and therefore, back to our statutory hook, substantially lessen competition. Okay? These are those two. So you can sort of split the world of anti-competitive theories of mergers into two groups, unilateral effect theories and coordinated effects. Everything I've said so far, the reliance on market share presumptions, all of that stuff, you could throw into the coordinated effects basket. So coordinated effects was the thing. This is the way that we thought about mergers until, let's say, 1982. Okay? And the idea was the market's getting more concentrated, and it's much easier for a group of, say, 3 firms to get together and fix prices than 4. So a merger that reduces the market from 4 players to 3 has a higher chance of increasing price. Okay? That was more or less the economic logic of coordinated effects. Still is. Not too persuasive because it predicts a price increase for every merger. Because notice that every merger reduces the number of players by at least 1. Okay? And it turned out the economic evidence said the coordinated effects theory wasn't predicting too well. Because you can think, and I'm sure if you sit here and think of mergers that come across the front page of your favorite newspaper, there are reasons other than colluding or desiring to collude with rivals that people want to merge. Sometimes you get assets of the other firm. One firm knows how to make something, the other knows how to market it. Lots of reasons to merge that don't have to do with collusion. And turns out if you look at the data, most mergers weren't resulting in collusion or higher prices. And so the world and antitrust agencies sort of revamped these theories. Where we get coordinated effects theories now is a sort of very special case. And I won't talk a lot about it because I want to talk to you about a big, important unilateral effect theory case. Unilateral effects are sort of what's new in the antitrust world in this sort of historical development. And by new, I mean introduced to the world in the early 80s, embedded in the guidelines for the first time in 92, and the agencies and private plaintiffs started bringing cases on these theories in the late 90s. Okay? So coordinated effects comes up in one place. Let's say you've got a situation where there's 4 firms in a market, and they've tried to collude over and over. You have evidence of it. Right? The 4 get together, they say, let's fix prices. And they all agree And one of the troublemaking fourth firm's a troublemaker, and he always agrees. And then he goes back and waits for the rivals to raise their cost, and he lowers his and steals the market. Okay? And then they talk to him, and they say, well, I thought we had a deal. And he said, yeah, let's do it again, sorry. And they do it again. Okay? Now, eventually, those three firms might figure out that if they really want to cartelize, they're going to have to buy this guy out. Okay? And so that guy, the troublemaking fourth firm who won't join the cartel and undercuts prices, is called a maverick in antitrust parlance. And you have theories occasionally where you've got good, solid evidence of attempts to collude, like in the stylized example I just gave you, where they then buy the guy out. Okay? And so you have, I mean, those are sort of very specific evidence-driven cases that you've got. The theory is not just structural. It's not we went from 4 to 3, 5 to 4, 6 to 5. If you walk into the antitrust agencies and they say, why is this merger going to raise price? And you say, well, because it changes the number of competitors from 6 to 5. They will yawn and send you home. You have to have a story for why this merger is going to affect the way that people compete. And if it's eliminating a maverick that was preventing collusion, you have that kind of story. This is, Oliver Williamson has a Nobel Prize in economics. When I tell you that this is part of the reason why he has it, you will all be mad that you are not, well, some of you may be, economists, because it turns out it's really easy to get a Nobel Prize in economics. So part of what he did was this sort of basic idea. There's a demand curve up here. This is the world at that high cost up here, that line across. Right? You've got a price and an output, and there's going to be a merger. And the merger is going to do two things, and do them at the same time. The post-merger firm is going to get some market power it didn't have before. It's also going to be able to reduce its costs. So after the merger, we're going to get some market power that's going to let us raise the price, but we're also going to get some cost savings. You have two things that happen. One, you have that red triangle is the losses to consumers generated by the merger. Merger created some market power, it wasn't there. That's a loss of consumer surplus. Under the antitrust laws, that is bad. We count that on the negative side of the scale. Then you have that blue rectangle, which are the cost savings. If I was to give you the agency approach to the merger law in a sentence, it would be something like this. This is oversimplified, but pretty darn close. If the red triangle is bigger than, stick with me, the part of the blue rectangle that is passed on to consumers, the merger is illegal. Now, there's only one tricky part there, the part of the blue rectangle. So that is savings that the firm has. Right? It reduces its cost. Profits go up. Some of that's passed on to the consumers in the form of lower prices or something. Some of it's not. The merger guidelines say the part that is counts, the part that's not doesn't. So we're going to compare the part of the blue rectangle that's passed on to consumers with the size of the red triangle. We're going to measure that stuff as directly as we can, and then we're going to go home. I want to talk about, not that, this. I've got 2 minutes, and then since Professor Ver's my junior colleague, I'm going to steal 3 of his. He'll get me back on a committee at school later.
More consumer surplus, I think.
So the big famous, I talked to you about coordinated effects cases and the way they work. They're relatively rare now. The big movement is in unilateral effects cases. The most important unilateral effects case in the history of merger law is the FTC's challenge of Staples Office Depot in 1997. Most unilateral effects challenges are now modeled after this. So this is the cover of American Lawyer magazine. It proves if you win a big important case, you get your picture taken on American Lawyer magazine. And the FTC was challenging Staples Office Depot. The merger guidelines had just been revised in 1997. This was really the first big challenge using a unilateral effects theory. The idea was the parties wanted to merge. No one in antitrust agencies likes bringing retail cases. The reason why is barriers to entry in retail are usually pretty low. It's fairly easy to enter a retail market. And so generally, the idea that you merge and increase price, well, someone else comes in pretty quickly. They're not very exciting cases to bring because generally you lose them. So They started, and weren't too interested in this Office Depot merger with Staples, and they started getting all these flyers. You probably cannot see the prices, but this is a comparison of flyers in Orlando, Florida, where there are 3 superstores, Office Max, Office Depot, Staples, and 1 superstore on the other side. Prices, same product, same flyer, much higher on the 1 superstore side. Well, there can be lots of differences between cities. I will fast forward and say that they did this with every city all the time, everywhere, over a big, long time period. And it turns out that the price differences look something like this chart, which was shown about 5 billion times during trial. Okay? Now, let me show you what you're looking at. This is prices at Staples and markets with the 3 superstores. This is prices where you had Staples and Depot, prices where you had Staples and Office Max, prices where you had Staples only. Now, you could have other differences between this markets, but remember I talked about showing directly rather than sort of indirectly? This is the direct part, okay? So they said, the FTC, looks like prices are a lot higher in markets where there's just 1 Office superstore. Great part of this, for another time, we'll all get together and we'll do this as an antitrust compliance class. So these are all Staples documents. Everything I'm going to show you is a Staples document, okay? So, or an Office Depot document, sorry. So these are all internal documents, right? Talk about making the government's job easy, higher prices in the 1 firm markets. Now, what the case ended up being about, this is my favorite document, Professor Verret, if I may ask for your help. I've got cities all the way across, and this is, they created a price index. LA was the most competitive market. You had the 3 superstores sitting on top of each other within 5 miles. So it is over here. This says LA, and it's set to 1. And so these differences are percentages. And in stores where they had 1 market, they gave them a different name. They didn't list them by their city. They were called, Professor Verret, what does this say?
Non-competitive.
They were called their non-competitive stores. As an antitrust defense mechanism, sort of story, this is bad to call your stores non-competitive stores. And it turned out they were non-competitive for a reason. Prices were 14% higher in those stores. This is that graph sort of made a little fancier for exhibit purposes. This was the case. The case was, what this merger will do is in markets where there are 3 superstores, there will now be 2, okay? So in markets where there are 3, we're going to merge, there'll no longer be Depot. So all the blues turn to yellows, right? And all the greens turn to reds. Prices will go up, we win, Staples take a shot. That's the case, okay? Now Staples gets to come on and say there are other differences, and they had a big fancy econometrician. There was a battle of economic experts between 2 really fancy econometricians that went to fancy schools, and they tried to explain away the price differences. The punchline, they couldn't, right? And so at the end, the price differences stood, sort of big raging debate over whether the defense should have done something differently. My story is not whether this is right, wrong, or otherwise, but that this is sort of the method by which modern antitrust cases are decided, right? This is what the agencies do. They look for direct evidence. There's a hypothesis that Staples and Office Depot care more about competition with each other than if a Walmart's present. Okay? Now, you can test that directly. They did. This is what they could show. Defense had a chance to rebut. The rebuttal case was sort of made in the same way. Did not successfully rebut. Plaintiff wins. Lawyers get on the cover of American Lawyer, go to big law firms and run big practices there. End of story. Okay? But this is really what Judge Posner describes Staples as the coming of age of modern merger analysis, mostly for that reason. And that is really the methodological foundation for the way that people are thinking about modern cases. I took 4 from you, so I'll buy you a coffee later. So, thank you.
Thank you, Professor Wright. As we move on to our second lecturer of the day, J.W. Verret, who is an assistant professor of law at George Mason University's Law School. Professor Verret received his Juris Doctorate and a master's in public policy from the Harvard School of Law and the Harvard Kennedy School of Government, respectively. And while in law school, Professor Verret also served an Olin Fellowship in Law and Economics at the Harvard Program on Corporate Governance under the guidance of Professor Lucian Bebchuk. Professor Verret then served as a law clerk for the Vice Chancellor John W. Noble of the Delaware Court of Chancery. And prior to joining the faculty at George Mason Law, Professor Verrett was an associate in the SEC Enforcement Defense Practice Group at Skadden Arps here in Washington, D.C. He's written extensively on corporate law topics, including a recent paper, Delaware's Guidance, co-written with Chief Justice Myron T. Steele of the Delaware Supreme Court. His academic work has been featured in the Yale Journal on Regulation, The Business Lawyer, and other journals too numerous to list for you today. Professor Verrett is also a senior scholar at the Mercatus Center Working Group on Financial Markets, where he regularly briefs congressional staff, members of Congress, and has been called to testify on Capitol Hill a number of times. And without any further ado, I will turn the microphone over to Professor Verrett.
Thanks, Jim, and I appreciate everybody joining us today for lunch. I was a little bit, I really enjoy the opportunity to come up to the Hill. I'm always inspired by, being here, by the dedication of everyone here, and just by being around, such an old and sort of awe-inspiring institution. But I have to say I was a little disappointed this morning, because when I got here, I brought my camera with me. I wanted to take a picture of one of the very popular monuments here, and that's going to be refurbished fairly soon. So I asked everywhere, but nobody could point me in the way of the debt ceiling, because I wanted to get a picture of the debt ceiling before it gets raised. So, but I'm really glad to be here. It's an honor to be here, and I look forward to talking with all of you for about half an hour or so about mergers and acquisitions. So Josh, Professor Wright has discussed with you how antitrust law reviews mergers and acquisitions. Now, before you get to Professor Wright's friends at the FTC and the DOJ, you have to consider a number of my friends at the SEC and at the state court. And so you have to consider the effects of a merger on shareholders. And you have to think about the legal structures at the SEC, both of the disclosure rules and also the approval process for getting the merger through. So let me start with a pop quiz. I like to have a question at the beginning of the lecture rather than the end. And I love multiple choice questions because, of course, grading is one of the most fun parts of being a teacher. Right? Grading stands in the way of the end of class and summer vacation. So I've gone to a complete multiple choice Scantron graded system, which I find is very, very useful. So let me give you a multiple choice question. What is mergers and acquisitions? What is M&A? A, is it a way for bankers and lawyers to get bonuses so big that the rest of the world hates them? Okay. Is it B, a way for CEOs to develop empires and make them feel like the Monopoly Man, right? Or Scrooge McDuck or something. Or is it C, a way for companies to create synergies between similar or complementary lines of business and add efficiencies they can pass on to shareholders and consumers? So which is A, B, or C? Who votes A? Who votes A? Nobody. Who votes B? B. Who votes C? We vote C. You're all wrong. It's actually all of the above. All of the above. Yes. Were you going to say all of the above? Yeah. Most of my questions are actually all of the above, as one of my former students here can remember. So yeah, I think it's a little bit of all three of those things. So mergers and acquisitions are a way for companies to come together and hopefully develop synergies that they can pass on to investors, pass on to consumers. Think about, does anybody watch The Office? I'm addicted to The Office. I watch it all day in my faculty office. So think about when Dunder Mifflin, the paper company, gets bought out by Sabre Holdings, the printer company, right? So the printer company thinks, well, we've got these trucks going out delivering printers. If we bought a paper company that has trucks going out delivering paper, we could put both of them on the same truck. And our salesmen that try to sell paper and their salesmen that try to sell paper, our salesmen try to sell printers. It'd be better if we put those customer lists together and we had maybe a smaller group of salesmen, because sometimes M&A involves cutbacks. That's one way to cut costs. But also we'd have a wider group of people. We could sell them both printers and paper rather than just one or the other. So that's the general idea behind mergers and acquisitions. So part of the review that M&A deals get is antitrust review for competitive effects on consumers. My area of the law deals mostly with investors, with the shareholders in these companies. They're involved. Make an offer for all the share, as many shares in a company as you can get. The tender offer process is very heavily restricted, regulated, and controlled by SEC rules. So those are the SEC rules that deal with the buyer, with the acquirer, right? So we've got rules about tender offers, and we've got disclosure rules coming out of the SEC. States also have a significant role to play. States serve as the creators, essentially, of corporations. These publicly traded corporations are created, they exist, their sort of legal personality is born in states because you file to incorporate a company, to create it at the state level. I'm very proud of Delaware. I worked in Delaware, and Delaware is the home of about 60% of all publicly traded companies because of its state law. State law is very developed. Long time ago, about 100 years ago, Delaware took on New Jersey and New York and said, you know, we're a small state, we don't have much, but we've got a lot of corporate lawyers that work for DuPont that want to find something else to do. So let's create corporate law and let's be a leader in that. And it's worked out really well for them. I think they get about half of the state's budget some years from incorporation fees. So that's a pretty good deal. So Delaware adjudicates M&A transactions. It's a big part of what Delaware does. And the focus there is almost exclusively on the target company. The target board of directors have duties to their shareholders to work in their best interest, to try to maximize the value of the company. And so Delaware has a number of procedures that kick in when a target company decides to sell itself. And it basically sets a bunch of hoops that the target's board of directors need to jump through in order to get an M&A deal approved. So that's a sort of a basic overview. Now, if I was doing a CLE for maybe practicing lawyers, I might sort of change the focus a bit. What I want to sort of do with the rest of my time is just give you a basic view of M&A, just a basic overview, talk a little bit about some of the areas of M&A law that you're likely to see, that are likely to find their way into the public policy arena, either things that were discussed under the Dodd-Frank Act, that didn't make their way in, that might make their way in later, or issues that the SEC is dealing with now that have found their way into congressional oversight discussions, or likely to, I think, very soon. And then I want to talk a little bit about a process that's part of M&A, but is very new to the M&A scene. It's been around for a long time, but has only become controversial very recently, which is the CFIUS review process, which is sounds kind of like a disease or maybe like a Greek tragic hero or something. But CFIUS stands for the Committee on Foreign Investments in the United States. It approves mergers where the acquirer is a foreign company. Sometimes, in the most controversial cases, a state-owned foreign company. So you remember the ports controversy in 2006. This was all stemming from the CFIUS review process. Congress has a role to play there. So I'll do a basic overview of the CFIUS process at the tail end of my discussion. All right, so 3 different ways to do a merger or an acquisition. You can buy all the stock of a company with cash. You can buy all the assets of a company and just leave the empty shell, the empty husk of the old corporation out there. Or you can merge with it. You can have your company merge with the other company. Think of, I don't know, one amoeba sort of swallowing another. And after a merger, the 2 companies become one entity, and the surviving entity gets all the assets of the old company and also gets all the liabilities of the old company. They can be sued for any torts committed by the old company before the merger actually occurred. So the purchaser will typically use stock to make the acquisition. It will typically give the target company shareholders stock in the acquiring, which will also become the surviving company. So the typical merger, from the investor's perspective, is one in which you get a notice in the mail that you probably throw away. I mean, most shareholders really just don't read these things. I teach this stuff, and I don't even read the notices from all the companies I own. I say all, the 2 or 3 companies I own like a couple of shares in. But anyway, you get these notices in the mail, and they say, we're going to merge, and here's some details about the merger that we're required to disclose to you under SEC law. Do you want to vote for it or not? If a majority of shareholders vote for a merger, the merger goes through. Even if you voted against the merger, it goes through, and suddenly, instead of being an owner in ABC Corp, now you're an owner of Google shares instead, because they've been exchanged for your shares in the old company that, let's say, maybe Google acquired and merged with. In some acquisitions, mergers don't actually occur. The parent company, the big company, the buyer, buys up a controlling interest in a subsidiary and decides to just maintain that controlling interest. And so there might still be shareholders in the subsidiary company. Coca-Cola owns 60% interest in Coca-Cola bottling, but you or I can go and buy shares in Coca-Cola bottling if we like to. But the typical case is a very simple merger in which the acquirer gets a majority of the target's shareholders to vote in favor of the merger. And before you get there, you got to go through the board of directors of the target company. It's also a very important step. You got to negotiate with the board. Why do you have to do that? Why can't you go straight to the target company's shareholders? Well, it can be tough. There are a lot of defenses out there that target company boards can use to defend against hostile acquisitions. Does anybody remember, I love 80s movies. Anybody remember the 80s movie, The Secret of My Success, with Michael J. Fox? He's at the end of the movie, he executes a hostile takeover of a company. He sort of rises up from the mailroom to the executive suite within like a week or two. Hostile acquisitions, very rare, very, very difficult to do for a number of reasons. So let's talk about the 2 ways you might try to do a hostile acquisition. Okay, you might try to buy up all the company's shares, or at least a majority of the company's shares, through a tender offer, through a hostile tender offer. You can try that. Then you'd own a majority of the shares, and then everything the company needs a vote on, including elections for the board of directors, you'd have a majority of the shares, so you could vote them, and then you could get your way, right, basically. There are a number of impediments to doing a tender offer without the target company's permission. First, there's a defense called the poison pill. There are a number of different sort of defenses. They all have kind of interesting names. I guess it's like M&A lawyers with fairly boring lives that try to sort of spice it up with all these names, like the poison pill defense and the crown jewel defense. I'll talk about a couple of them because I think they're kind of cool, and they're kind of inventive, I think. So the poison pill defense is one in which the company's charter or bylaws have a provision that provides that anytime someone acquires more than a certain percentage of a company's shares, everyone but that buyer gets essentially free shares, right? It's a great deal for everybody but the hostile acquirer. Imagine you lay out a bunch of cash to get 10% of a company, and you want to keep buying more and more, right? You get past that threshold. It's typically 20%, but at some companies it's going as low as 5%. You get right past that threshold, immediately all the other shareholders but you get free shares. They typically get to buy shares at a deep discount, but effectively it's free shares. So suddenly, think about your percentage ownership used to be 10%, but now everybody else had shares, so now it goes down to 8 or 7 or 6. And then you buy more shares, and then everybody else gets to buy free shares. So you spent money to get back up to 10%, but then you went back down to 9, 8, 7, 6, 5%. So it's like one of those movie fans where the wind's coming at you and you're walking, but you're just not getting anywhere, right? That's what a poison pill essentially does for a potential hostile acquirer. It would be foolish for anyone to buy into a company that had a poison pill in place or that put one in place in response to your hostile acquisition. So you got to go to the target board. You got to negotiate with them if they've got a poison pill in place or threaten to put one in place and get their permission to do the acquisition. So you have to negotiate with them. Now, these are very controversial provisions. Proponents of them say they're great for shareholders. They help shareholders in the long term because it forces the hostile buyer to negotiate with one person, with the CEO of the target, right? And the CEO of the target alone is going to have a lot more leverage in that negotiation to get a higher price for the target company's shareholders. If the buyer went out to the market of millions of shareholders and said, hey, I'd like to buy a majority of this company, everybody else is going to get left out in the cold, and I'm going to control it. So you better hurry up and buy into my tender offer. I'm buying a small premium to market. I mean, I might think about selling into that, and a lot of other people might as well. But with a CEO, the CEO can say, hey, you got to buy the whole company, and you got to pay a 30% premium over the current market price, or else I'm not going to rescind the poison pill. Well, proponents of the poison pill say that's what happens. That's what poison pills do. Critics of the poison pill say, no, that's not what happens. What happens is these CEOs get these really cushy gigs, and sometimes they're doing really terrible jobs. And it would be great if somebody with a lot of capital and a good idea about how to turn this business around could come in, make a hostile offer, take over the company. We'd have a sort of market for corporate control that could discipline these managers. Just the prospect of it happening could discipline managers. And at failed companies, we could come in, we could have somebody buy up the company, buy up a controlling interest in the company, kick the bums out, pay premium to shareholders in these companies that are doing very badly. It could really be great. It could really shake things up and get things moving. Where's the truth? Like everything else, like all these other major issues, probably somewhere in between. Not sure exactly where. A lot of debates over where it is. Institutional investors, large institutions like mutual funds, like pension funds, union pension funds, or private pension funds, or state-controlled pension funds, find the poison pill fairly controversial. At some companies, they've tried to get rid of the poison pill, companies they particularly don't like. This is an issue I think we're likely to see debated at some point, in these halls, and that we have seen debated during the hearings leading up to the Dodd-Frank Act. Nothing made its way into DFA about poison pills, but I think just an issue you're likely to see come up again and again. Staggered boards. What's a staggered board? Well, I'm sure you're very familiar with staggered elections. Here in the Senate, the elections are staggered. A third of the members go up for election every 2 years, as opposed to the House, which has, every 2 years, everyone goes up for elections. Well, about half of all public company boards are staggered boards, boards in which about a third of the board goes up for election every year. About half of all publicly traded companies have boards of directors that go up for annual elections. The whole board goes up every year. What's the difference? Well, it's a lot harder to do a hostile acquisition, even if there's no poison pill. It's a lot harder to do a hostile acquisition of a company with a staggered board. Because you might think, well, let's see, the company's refused to rescind their poison pill. Oh, no, what can I do? I can do a proxy fight. I can do a proxy fight. If I can convince if I can't buy a majority interest in the shares, maybe I can just convince a majority of the other shareholders to go along with me, that I've got a good idea. They'll kick the current bums out, put in my slate of nominees. My slate of nominees has told me they're going to get rid of the poison pill. Then I can do a hostile acquisition, right? But doggone it, the corporate defense bar thought of that too. So they created staggered boards. So it's tougher to run a proxy fight when there's a staggered board because you got to run a proxy fight, then you got to wait a year. Then you got to run another proxy fight. That's a year time frame that in finance is a lifetime, particularly the kind of finance that finances M&A deals, very high-yield bonds. In the old days, they called them junk bonds. Now they call them high-yield bonds. Yeah, the high-yield bond market doesn't want to wait around a year on the contingent prospects of 2 proxy fights. So there's just no financing available for taking on a staggered board. So it's a lot easier to run a proxy fight in a non-staggered board. Now, this issue was debated very hotly in the lead-up to the Dodd-Frank Act. I should disclose I testified against mandatory annual elections. There's a lot of people that argued in favor of mandatory annual elections. I see Dean Shahinian's here. I know he's familiar with this fight intimately. So there was a provision requiring mandatory annual elections for all publicly traded boards of directors. Didn't make its way into DFA, but I think issue we're likely to see debated again and again, either in terms of SEC rulemaking, SEC disclosure requirements, or possibly mandatory annual elections. And I should share with you, I always like when there's a little interchamber rivalry between the Senate and the House, and And Senator Corker observed, he said, there's a body on the other side of the mall that doesn't have staggered elections, and sometimes they don't deliberate very well on their decisions. So I think that speaks in favor of staggered boards. I thought that was a little friendly jab at the House, but nevertheless an issue that comes up a lot, and I think that you're likely to see in your policy roles. A couple of other defenses that are fairly popular: the white knight defense, which is just a fancy way of saying you don't like the hostile acquirer, so you go find somebody friendly to buy up a big piece of your shares. Warren Buffett had a huge business in this. He loved to be a white knight because he always had tons of cash, and he said, yeah, sure, I'll be a white knight. Let's see. Give me preferred shares that have a dividend of 10%, and he always charged a huge premium for being a white knight, but he loved to serve in that role. He made a lot of money doing it. There's the Pac-Man defense, which is just a fancy way of saying instead of them gobbling you up, you gobble them up. Now, you got to have a lot of cash to execute the Pac-Man defense, so it's rarely used. And targets of hostile transactions are usually sort of in trouble. They usually don't have a lot of cash themselves. But sometimes the Pac-Man defense can work. Golden parachutes and 10 parachutes are sort of the answer to the poison pill. Now, they're an expensive answer to the poison pill, but if it's hard to kick the bums out because of poison pills and because of staggered boards, well, the golden parachute is sort of a buyout. It's a way of saying, hey, if as a result of a hostile acquisition, or in some cases a non-hostile acquisition, you're kicked out, you get a huge parachute. You can go live in the Caymans in a beautiful house and retire. It's a large payment, right? That's why golden parachutes are very controversial. 10, 20, 30, $50 million as a reward for a failed management career. It's controversial when it happens. But if it's the price of getting rid of a bad CEO in a way that will allow new management to come in and make billions of dollars for the shareholders, maybe it's worth it. But that's not an argument that you can pack into a soundbite, right? So it's a lot easier to, I think, attack golden parachutes in the general policy realm, and that's why I think we saw, in addition to the arguments, on either side, we saw golden parachute disclosure rules make their way into SEC rulemaking, and a mandatory advisory vote on golden parachutes make its way into DFA. So if you want to adopt a golden parachute now, you have to have a shareholder advisory vote on it. It's non-binding, but it's really embarrassing if your golden parachute plan is voted, even if 20 or 30 or 40% of shareholders vote against it, it's fairly embarrassing, makes its way into the news. And so I think it certainly did change company policies about golden parachutes. 10 parachutes, by the way, are golden parachutes that cover the blue-collar folks at the company. So they're called 10 parachutes. And they have the added effect of saying, oh, hey, we're just trying to protect our union workers, right? So it's easier to adopt a 10 parachute maybe sometimes than it is a golden parachute. In any event, those are the major sort of working parts in those defenses. So we've talked a little bit about tender offers, a little bit about proxy voting, proxy solicitations. I want to talk to you about proxy advisory companies because they have a big role to play in mergers and acquisitions as well. What are they? Well, if every merger involving a target company, the company that's abolished at the end of the merger, requires a shareholder vote, then you got to think about who's voting for these things. Well, retail shareholders like you and me who own through some online stock trading company or through your Fidelity broker can vote, certainly. And people like us represent about 30 to 40% of the shareholder electorate, depending on how you count. The other 60% is made up of institutional investors, mutual funds, pension funds, insurance companies, things like that. Some of them are required to vote. They can't not vote. There are Department of Labor rules that require them to vote. There are SEC rules requiring them to vote. And so there's not a lot of money to be made in shareholder voting, to be honest. Mutual funds hate doing it. They'd rather not have to vote either way at all. It's just the back office of a team of lawyers you have to hire to decide how to vote. And then they have to vote, and then they have to decide why they vote the way they did. Right? They have to think about all these proposals that come through. There are 13,000 publicly traded companies in the United States, and they all have elections every year. So, you got to get advice about how to vote in those elections. Every M&A transaction has at least, one shareholder vote involved. And so a business sort of evolved of proxy advisory companies that said, well, we'll tell you how to vote. We'll tell you what you should do. And their advice carries a lot of weight, carries a great deal of weight, and can often make the difference of, I'd say, about 20 to 30% of the vote in some cases. So some people argue it's more like 15, some people argue it's 30, but let's just call it 20% of the vote. That's often the margin of victory in M&A transactions. So advisory companies carry a lot of weight. It's an industry in which there's a lot of consolidation into one firm. Institutional shareholder services sort of leads the business, and it's a very controversial company. It's got metrics it uses internally to decide how it advises elections for the board, how it advises an up or down vote on a particular merger, and there's a push to regulate them. The sort of thought among publicly traded companies, the industry idea is, well, look, after DFA, you regulated us, so guess what? Next time our friends rule the roost, we're going to regulate you. I think that's the big debate we're likely to see after DFA implementation is all gone through, is either SEC regulation or congressional legislation on proxy advisory firms. It could take a couple of different avenues. One is that ISS is voluntarily registered as an investment advisor with the SEC. There's some question of whether or not they're required to do so. They might be required to do so. There's some thought about, well, maybe we should make ISS disclose more about the metrics they use to recommend up or down votes on mergers and the other things they recommend votes on, and then make them liable for that disclosure so that private plaintiffs could sue them under private rights of action under the proxy advisory rules. And then there's some thought that maybe we should regulate at the issuer level and say, well, one of the things that really keeps ISS alive and keeps the other proxy advisory firms alive is they don't make nearly enough on proxy advisory services for institutional investors. So what they've done is, and this is a pretty good trick, in addition to advising shareholders, right, they also advise issuers. And they say, well, we have this wing in the other wing of the building that is going to tell your shareholders how we're going to vote. But we've got these analysts on the other side of the hallway that don't talk to those analysts at all. There's a brick wall between them. You can hire them, and they can advise you on how to structure your M&A deal or your election or other things to get a good recommendation from the people on the other side of our hallway. And it turns out that a lot of issuers spend a lot of money on consulting fees for this, and those consulting fees are the lifeblood of ISS. If ISS had no more consulting fees, I think probably, there's not a lot of disclosure about ISS finances, but I think probably ISS would be done, or they'd have to raise their rates on the institutional investors. So it's a fight we're going to have at some point, and I think it's going to be a fun fight to hope I get a chance to get involved in it. And I see Dean smiling in the back. I think it's a discussion we're likely to see, so something I wanted to kind of sketch for you a little bit. Other pressing issues, Chinese reverse mergers. This is an issue that's made its way into the popular press quite a bit. What are they? Well, initial public offerings are very expensive, and they're very time-consuming. They're highly, highly regulated. Right? This is the IPO. This is when you first make your offering of securities as a company to the market, when you go public. Very heavily regulated stage of a publicly traded company's life. In fact, probably the biggest step. So some companies have an interesting idea. They say, well, there are companies listed on the exchanges, both the big exchanges and also the over-the-counter exchanges, which are less heavily regulated in terms of ongoing regulation. Still have a lot of heavy regulation for the IPO stage, but less heavily regulated going forward. They have shell companies that just have, for some reason or another, just sort of gone bust, but they never delisted from the exchanges. These shell companies are still there. So some companies that want to access U.S. markets say, well, we could go public, or we could just buy a company that's already listed on the exchange that's a shell company, and after we buy it, we could have it merge with us, and then we'd be listed on the exchange. And then we wouldn't have to do an IPO, and we'd get listed, and we just sort of sidestep the IPO process. Now, this sounds like a kind of a conspiracy theory-esque. It actually works very well most of the time. There are certainly high-risk companies, a company that's done a reverse sort of reverse merger means to access markets is a high-risk company, but with risk comes great reward. But recently, we've seen a lot of Chinese companies, which almost always, in some way, effectively means state-owned Chinese companies, accessing U.S. markets in this way. Now, what happens there? Well, there have been a lot of fraudulent reporting from Chinese reverse merger companies. And China, there's supposed to be some reciprocity among auditing regulators, but the PCAOB here, the entity we have that regulates auditors, has said, we want the ability to review Chinese firms auditing Chinese companies, and China said, no, we're not going to do that. Trust us. We're going to handle our own auditors of our own companies. We regulate them. We own the companies. So we're all just sort of one big happy family. It'll be fine. And it's not fine. And it's a big deal. It's a big issue. I think you'd have to be crazy to invest in a Chinese reverse merger company. The SEC's on the case, of course, and they have issued an investor bulletin that says, and I'll quote, it has a lot of background about this, and then the big advice from the SEC bulletin is, be aware that when someone gives you a hot tip, always ask what motivated them to do so. Keep in mind that information on mass emails or websites may be intentionally misleading. So the SEC, the investor's top cop is on the case, and they've got this fixed, the masters of the painfully obvious. They don't really know what to do with it because it's big business when it works well, and in a minority cases, particularly involving Chinese companies, it works really badly. So I don't know what to do about that, but it's something that the SEC is going to have to do and something that I think you're going to have to think about as well at some point. So with that I think gives you a basic overview of M&A and an idea of some of the advanced issues that are likely to make their way into federal policymaking. I want to just talk about the CFIUS process for a little bit because I think it's interesting. It's part of M&A, and it's something that Congress is already getting very heavily involved with, and I think is likely to at some point in the future as well. So the CFIUS is short for the Committee on Foreign Investments in the United States. It's made up of the heads of Defense, Treasury, Homeland Security, Justice, Commerce, the head of the Council of Economic Advisors, head of the NEC, head of the CIA, now the National Intelligence Director. It's a group of 13, 15, 16, something like that, agency heads that get together to review mergers in which the acquirer is a foreign company, a foreign person as defined under the statute. A couple of interesting examples. I don't know if you remember, there was a Chinese company, CNOOC, interested in buying Unilateral, and it didn't actually go all the way through the CFIUS process. Like most things that seem like they're going to lose CFIUS approval, the board at the end, Unilateral essentially said, we don't want to deal with the CFIUS headache, so they sort of refused to sell to CNOOC, refused CNOOC's offer. But the thought was sort of, do we really want China owning like a fifth of our energy reserves? Might be a bad idea, right? That was the sort of controversy there. CFIUS process was created as part of a 1988 amendment to the Defense Production Act. It gives the president authority to investigate the impact of mergers or acquisitions if two things are true. One, there's credible evidence that the merger will impact national security, and two, no other law gives him adequate remedy. But, and this is the kicker, the president's findings are not subject to judicial review. Unlike the FTC, unlike the DOJ, unlike the SEC, unlike Chancery Court, which is judicial review from the very beginning, no judicial review of the president's CFIUS decision. So almost unfettered authority. And the only real check there is the political check, essentially, of congressional oversight and interagency rivalries that are also are a big part of the CFIUS process, and the public getting involved as well, which was a big part of an example that I'm going to give you in a minute. So the CFIUS committee essentially makes findings about potential mergers, and they recommend to the president what he should do, and the president essentially takes action. Now, CFIUS is often a voluntary review process. I think, in fact, in every case, it has been voluntary. Here's the deal. The president can use his powers under the Defense Production Act essentially at any time to rescind a merger after it has gone through with no time limit unless you go through voluntary CFIUS review. So it could be really, really costly if you do a merger without going through CFIUS that involves a foreign person that has any potential national security implications. The process is meant to be confidential. It's led by the Treasury Secretary unless there's some specific national security interest of the Defense Department. Historically, it typically involved mostly companies that made items that were already regulated in lots of other ways, under export controls and other controls. So you can imagine, a producer of missiles being purchased by a foreign company. That's a very easy case for CFIUS review. And in fact, the CFIUS review was probably redundant because a number of other bodies would have already looked at the merger and determined whether or not the specific items produced by the company that was the target of the merger by the foreign person, by the foreign company or foreign person, they would have already done that process, and so CFIUS review would have been essentially redundant. So it was a pretty sleepy process until the sort of post 9/11 environment, when I think we started to think in much more depth about what national security means, right? So I want to talk a little bit about the port acquisition, and then sort of close it up. I think we'll have about half an hour for questions. So in 2006, the Dubai Port Authority wanted to purchase an interest, a controlling interest in a British company that had essentially contracts, management contracts with about 6 U.S. ports, right? The British company didn't own the U.S. ports, although that was often part of the discussion in the broader media. It only owned contracts to manage parts of the ports. So they would do the stevedoring. They would essentially take the boat and help guide it to the port, right? From the time the good left the ship, went into the port, and then left, it was all carried by U.S. union workers, right? From the cargo hold on, union workers sort of handled it until it went in the trucks. But taking it from the river or the sea to the port would be done by this British company, essentially. And they didn't have exclusive control of any of the ports. At the Port of New York or the Port of New Jersey or New Orleans, they would have about maybe a sixth, a fifth, a fourth of the port. They would handle that, right? So the British company owned licensing rights or management rights or just contractual rights of some kind or another to handle it or to subcontract to other people to do it. So the Port of Dubai is one of the largest ports in the Middle East. In fact, it is the largest port in the Middle East. It's one of the largest in the world. It's grown very quickly with the sort of resurgence of Dubai as a financial hub and as a trade hub. So the Port of Dubai is controlled by a company called DP World. DP World is owned by the royal family of Dubai, right? So it's state-owned. It's a state-owned company. So it's got two things going against it already for CFIUS review, right? We're very suspicious of the Middle East and China in CFIUS review. I think that's sort of an unspoken rule. And we're very suspicious, and this is actually part of the regs, I think, of state-owned companies buying U.S. companies, right? We're a lot more comfortable with private companies for some reason, for a number of reasons, I guess. Dubai, though, let's remember this. Dubai is an American ally, right? It's a port of call for U.S. warships. It's been a partner in the terrorism investigations. At the same time, Dubai is a place in which, it's sort of the financial hub of the Middle East, so it's not surprising that money laundering that supports terrorist activities goes through Dubai. Hawaladars, send money through informal networks, and the Dubai exchanges are sort of where the Hawaladars, the Hawala, bankers, informal Islamic bankers, sort of trade. And so in some instances, we've seen U.S. money laundering investigations touch on things in Dubai, but there's been no evidence to implicate the government of Dubai in any of those activities. So you can see the sort of the story building. So DPA World goes to CFIUS in December of 2005 and for review of the transaction. The Coast Guard and the Department of Homeland Security have some concerns. And the Coast Guard has a report where they say, well, we don't know a lot about what goes into ownership of these ports. We don't know a lot about the owners. And so we're a bit concerned. So DP World sits down with Homeland and sits down. It's a very consultative process. In fact, before the formal application, anybody going through CFIUS will sit down with bureaucrats from all of these departments and just talk to them and say, look, we're about to structure a transaction. What kind of transaction will you like if we bring it to you? And they'll, the CFIUS has so much power that consultation guides the shape of the transactions even before they get to CFIUS. So eventually DP World settled all of the concerns raised by Homeland and raised by the Coast Guard. CFIUS process is going through swimmingly. They get to a point at which CFIUS has to make official report to Congress about the progress of the deal. The merger, the acquisition has been mentioned about 100 times in U.S. media in December and January. Suddenly, for some reason, in February, it just blows up. It explodes onto the national scene. It becomes a major story for a couple of weeks. Terrorist financiers buying control of U.S. ports becomes the headline, becomes the story. And it involved a unique coalition of folks on both right and left. So you can imagine the conservative commentators, Michael Savage was all over this story. We're selling our crown jewels of America to terrorist financiers from the Middle East. Folks from the other side of the aisle were also very concerned. Senator Schumer, certainly very concerned, had a stake in it because of the Port of New York, had a press conference at the Port of New York and said, we will not sell this port to terrorists. So there was a lot of dialogue, a lot of very politically laced dialogue on both sides. And Congress has no official role in the CFIUS process. But Congress said, well, we're going to pass a bill to block this merger. We're just going to pass a bill that says this merger can't happen. Well, you could pass a bill like that, but I don't know if you could force a bill like that because there's some constitutional issues there. But anyway, when Congress makes trouble over a merger, it just makes the merger less likely to go through, right? So in the end, the merger goes through. But the DP Dubai world wants to do everything it can to just minimize political risk here. So they say, well, look, here's what we'll do. We'll take all the contracts at U.S. ports and we'll put it in a subsidiary and we'll sell that subsidiary as quickly as we can. Frankly, we don't even care about the U.S. We bought this thing because of Australia and Asia and Europe ports where it does business. The U.S. business represents about 10% of the business we're buying, so we're happy to sell it off. Eventually, they sold it off to AIG. They bought the whole company for about $7 billion. They sold off the subsidiary doing U.S. stuff for about $700 million, and they got out of it as quickly as they possibly could. But I think it just shows you an example of how there's a sort of technical legal process for CFIUS. There's a broader political backstory and overhang that I think you got to think about. Part of the political issue and part of the policy debate that went on after this controversy was congressional involvement in the CFIUS process. Congress just wanted to have the right to be more involved. And then, of course, they, as the media story died, Congress lost interest in the issue as well. But there was passage of some minor changes to the CFIUS process. One, Treasury doesn't always take the lead on CFIUS anymore. Sometimes Homeland or Defense can take the lead. There's a greater role for the Director of National Intelligence. The Treasury has to make annual reports to Congress about the year's sort of CFIUS approvals for that year. And CFIUS is just getting more active in formally investigating mergers that come before it. Congress wanted an explicit role in CFIUS approval. It did not actually pass anything requiring that, but with the next scandal, maybe we'll see it happen. I don't know. But for now, it has gone back to something more of the sort of sleepy process that it was before. A little bit more active than it was before the 2006 controversy. Every once in a while, you see something come up. But I think the biggest change in the last 10 years has been the definition of what a merger that touches on national security means. Used to be just missiles and bombs, but now it's ports. Now it's energy. Now it's stock exchanges. Is the stock exchange something that we want foreign companies to own, right? As far as I know, the NYSE Deutsche Börse merger went through CFIUS very swimmingly and apparently had to. I don't even know if it went to CFIUS review, but just the definition of what national security means there is much wider, and there's not a lot of certainty about what Treasury and Homeland and DOD and Congress will decide it covers. In one interesting case, I'll just sort of close with this, is a case of a foreign company buying a U.S. telecom company. And part of what was owned there was undersea cables, fiber optic undersea cables. And the thought was, well, we're not worried about the foreign owner at all. They're a perfectly innocuous company. They're not state-owned. They're not from a controversial country. What we're worried about is, and DOJ and FBI sort of raised this, they said, well, we think it'll become harder to wiretap after this acquisition than it was before, because we'll have a foreign company that will have less of an easy time sort of pressuring. And so merger didn't go through, right? We didn't, very different from the sort of CFIUS process we saw pre 9/11, particularly wiretaps of overseas calls, right? The NSA spends a lot more time doing that than they used to. So it's not easy to know whether you'll be covered by CFIUS or not. I think it's an interesting area. Hopefully I've given you a little bit of an overview of the CFIUS approval process for foreign acquisitions, sort of one of the more politically laced elements of M&A. Hope I've given you an overview of basic M&A law from the securities perspective and state corporate law perspective, and hope I've given you an idea of some of the things you're likely to be asked to make decisions about fairly soon in this area. And thank you for the attention. This is fun.